Sri Ram's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello students, welcome to Sri Ram's IAS. Welcome to this marathon number 2. We have already done marathon number 1 on the current affairs of Indian polity. Indian polity is a very important subject. Around 15 to 20 questions are asked every year and current affair forms a very important part of your preparation. So enjoy this marathon. Try to learn from this marathon, and this marathon is going to help you in your upcoming prelims examination of 2025 on 25th of May. Post-retirement appointments and independence. So we have seen that judges in India retire at the age of 62 when they are the judges of the High Court, and at the age of 65 when they are the judges of the Supreme Court. Okay. Now, usually if you see at this age, at the age of 65 and 62, they are not so old that they are unable to work. They still have 10-15 years left where they can work without their physical body being in a state where it will be a problem in their working. Okay. And given the kind of experience these people have in the public life, in the judicial life, it becomes very important that we need to create some sort of, mechanism for what they can do, because they, on the other hand, they also hold very important posts, judicial posts. So if somebody is a judge of Supreme Court, let's say, and he's going to retire at the age of 65 and the person is very fit, a lady or a gents, anybody, now what will happen? He is going to think about post-retirement options, what the person will do after the person gets retired at the age of 65. And that is where the executive jumps in by making, offers, that you can be made a governor, or you can be given post of in some tribunal, a judge of a tribunal, or you can also join the political party and do something. So there are options. But think about the situation when the executive makes such an offer to the judge of the High Court. Don't you think they will influence their decision making in one or the other way? Maybe they can influence their judgment in such a way that the judges start to give decisions in favor of the executive. And for your kind information, most of the cases and maximum of the cases which are filed in the courts are against the state. Now, if state starts to influence the conduct of judges because of the post-retirement promises that we are going to give you this and that posts, it becomes very difficult for the judiciary to work independently and impartially. Don't you think so? That's a big issue. So, in the past, we have seen that 28 Supreme Court judges have retired in 5 years. 6 judges, constitutional or statutory position post-retirement. 6 judges, and many other judges have taken many other things post-retirement. And this is nothing wrong, because at this age, at the age of 62 and 65, they have so much thing inside them. They want to work. They just don't want to get retired. For example, if a judge is going to get retired today and he is totally active today, how can one imagine that the person becomes totally inactive from tomorrow? That does not happen. That is not how people work. That there is no other work for him. He can take a break of 3 months, 4 months, 5 months or a year and then start working again. But where the person will work? Okay, that is important. Because if promises are made by the executive, it can affect the decision making of the judges when they are actually sitting in their posts, sitting on the chair of judges. Okay. So, for example, these are the names of the judges. Adarsh Kumar Goyal has been made the National Green Tribunal on the same day of his retirement. Okay. Justice Arun Mishra has been made after 9 months of his retirement, the member of National Human Rights Commission. Justice Ashok Bhushan, after 4 months of the retirement, he has been given a post. Hemant Gupta has also been given a post after 2 months of his retirement. P. Sathashivam, the governor of Kerala. S. Abdul Nazir, the governor of Andhra Pradesh. 1 month after the retirement, and Justice Ranjan Gogoi has been Rajya Sabha MP after 4 months of his retirement. Now the post is, these judges, they have high, experience. They have too much of experience, high volume of experience. What they are going to do post retirement, to be some mechanism. But the point is, all the post retirement jobs are coming from executive, from the government. So the question comes, when they were judges, don't you think the executive may have in a way influenced their decision making? Now this is one thing which, these are kind of questions which are asked everywhere. And I am not saying that these judges are involved in something. No, I am saying the questions are asked. There has to be some sort of mechanism that after retirement of judges, something needs to come up for their well-being, so that at this age, I would call it a young age, this one 65 and 62, at this age they have so much of energy inside them that they can still work for 10-15 years, and some mechanism needs to come up. But at the same time, the independence and the impartiality of the jury has also to be maintained. Now, there are several suggestions with regard to this. There are also several constitutional provisions with regard to this that will be helpful for your upcoming prelims examination. We will see. There was a debate, okay, in the Constituent Assembly, and that kind of debate, one in the favor of post-retirement appointments and one against the post-retirement appointments. So, K.T. Shah proposal, he made a proposal that the post-retirement should be barred. The retired judges should be barred from holding executive offices. At the same time, they feared government influences through post-retirement appointments. H.V. Kamath also said something. Shibban Lal Saxena, they warned that the executive could influence the judiciary in key disputes. Also, post-retirement appointment are no problem. These were the statements made in favor of post-retirement appointments. Dr. B.R. Ambedkar said it opposed the ban, arguing that judiciary is not primarily concerned with the executive. Means these are two different things. So why there is going to be any kind of influence? At the same time, unlike UK, where the retirement age is 70, and USA, where there is a lifetime tenure, India's judges retire quite early, so they need some sort of job after retirement. And if the government is coming up to give them some post, what is the issue in that? Judges need opportunities post-retirement due to low pensions. Yeah, this is also one of the issues. They have been getting some salary and all kind of benefits when they were judges, and all of a sudden everything is gone. The salary has become half. The allowances given to them and all other kind of, they have to empty up the space where they were living, the house. They need something. Okay, so these were the issues which were arguments which were in favor of the post-retirement. So Dr. Ambedkar believed that the executive would not meddle in judicial affairs, but the emergency from 1975 to 1977 proved otherwise. Okay, what happened during that time? We are going to see that the ADM Jabalpur case was there. Article 21 and Article 226 were scrapped. So few decisions or the orders were made by the judiciary during the period of 1975 to 1977, which have actually portrayed that the executive interference in judiciary can be there. Judiciary may not at times be impartial, can be partial also, can favor the government in important cases, and that is the reason the meddling can be done, and that is the reason the independence and the impartiality of the judiciary has to be maintained. The constitutional provisions are Article 124 clause number 7. What does it? It prohibits the retired judge of the Supreme Court from practicing before any other authority of India. Now think about a person who has retired at the age of 65. He has all kind of experiences, but he cannot appear before any other court in India, including the Supreme Court. He sits at home doing nothing. Okay, think about the mental condition of the person. He needs some job, he needs something. This restriction is aimed at maintaining the independence and impartiality of the judiciary. However, the Constitution does not explicitly prohibit retired judges from accepting post-retirement assignments or of appointments. So, they cannot go and practice law in front of any other court, including the Supreme Court, okay, or before any. There is prohibition or bar, no strict prohibition or bar after the post-retirement jobs. They can do, follow the assignments. That is why the executive comes up to give them some sort of job. They can be made as the governor of a particular state, a lieutenant governor of a particular union territory, or the you can be given the post of judges in National Human Rights Commission, other tribunals. Also, they can be made the Raj Sabha members. They can join the political parties and fight elections. There are many avenues which are open to them. But again, it raises the question of judicial impartiality. Now, Article 128 is an important constitutional provision where if there is a lack of judges or there is a vacancy, the Chief Justice of India, with the consultation of the President of India, can ask for retired judges. Retired judges, this is a special provision that the President consent may request a retired judge of the Supreme Court, Federal Court, or a High Court qualified for the appointment of the Supreme Court to sit and act in the Supreme Court. So, acting judges. There is a provision of acting judges. The power is given to the Chief Justice of India. He, with consultation of the President, can ask any other judges. The basic requirement is the judge, whoever the person, the Chief Justice, Honorable Chief Justice is asking to come and sit as a acting judge, must consent for that position. It's not an order, it's a request made to them. Post-retirement, that we do have vacancy here, and please, if you could come and be the acting judge in the Supreme Court. They will be given all kind of facilities which are given to the sitting judges of the Supreme Court. Article 220, this provision is about the High Court, that it bars the High Court judges from pleading before any authority in India. Any authority except the Supreme Court and other High Courts. So, there is a kind of bar, the High Court judges also cannot go on and practice anywhere, except they can go and practice in Supreme Court and in other High Courts. They can practice. But there are many bars, many other judicial authorities are there where they cannot plead. They need some job after retirement. So, the emergency period, as we have discussed, especially the ADM Jabalpur case, this ADM Jabalpur case became a cornerstone case. Why? Because this was seen as a interference, the executive interference in the judiciary, where executive has influenced judiciary to give decision in favor of it. And that is the reason why the question of judicial impartiality and the executive meddling into the judicial affairs keeps coming. And that is the reason why we have also seen this post-retirement is one thing, but we have also seen in the previous video that Lokpal was trying to extend its jurisdiction and was trying to bring the High Court judges under its ambit, which was fiercely, suppressed by the Supreme Court. The judgment is still pending, but the Supreme Court was not very happy with this affair. So, in favor of post-retirement appointments, why there should be post-retirement appointments? Because judges' experience should not be wasted. Okay, we have already seen why the post-retirement appointments must not be given in order to, establish the authority of the Supreme Court as an impartial court and the authorities of the High Court as the impartial court. to maintain the independence of judiciary, to maintain separation of power, that one organ of the government does not meddle into the affairs of the other, and to maintain the criminal justice system which should work appropriately in the country. But there are also arguments in favor of it. Why the post-retirement appointments can be given? Because the judge's experience should be used. It should not be wasted. Think about their 30 years or 40 years experience. If you are just wasting them, then what's the use? They can be put into some good use in this country. It's a huge country and we need help of every last person, especially the people like judges who have very vast experience. No legal bar on post-retirement rules. There is no legal bar as such. Article 124 and Article 220, they just say that few judges of the Supreme Court and the High Court cannot plead in the authority from where they are retiring. So there is no actual legal bar on it that they cannot join a political party, cannot become a member of the Rajya Sabha, or cannot be the governor of any state. They can be fulfilling vacancies requiring specialized knowledge, especially if you see tribunals. They are of great help. For example, National Human Rights Council, okay, NHRC, if you see this commission, specialized knowledge of a judge is required, okay, and that is the reason if you ask the sitting judges to be here, it becomes quite taxing on them, because they already have the mainstream judicial work. But the post-retirement judges whose experience needs to be used can be requested to sit on the panel of National Human Rights Commission. It becomes very important. This can contribute to judicial institutions. Yes, can be ensuring integrity in official positions. So this is a very important issue, very important for your prelims examination also. These three articles, the establishment of the Supreme Court by Article 124, and also there are many clauses. Clause number 7 prohibits the Supreme Court judge to practice in front of any other court, including the Supreme Court. Article 128 is a provision that a post-retirement job can be given by the Supreme Court. If there is a vacancy in the Supreme Court, as nobody is there to fulfill it, they can act on the request of Chief Justice of India as the acting judge of the Supreme Court. And then Article 220, which prohibits the judge of the High Court to take up pleading in front of any other court except the Supreme Court and the other High Court. So these are important provisions for your upcoming prelims examination, and this issue is very important. And that new topic is about governor. The issue of governor is always there for one or the other reasons in the current affairs, and this time the governor as Chancellor of the universities in state is the issue. Now you all know, you all have studied Indian polity, and you know the structure in India. We are a uniform government, kind of a government. We have the tilt is more towards the union, although there are features of federalism in this country, but the tilt is always towards the union, and for that reason governor holds two important positions. It has two important roles. One as the head of the state. Head of state, this is a constitutional position held by the governor of a state. And second important thing is he is the representative of the central government in the states. So this is particularly an important element which tilts the balance towards the center rather than towards the state. And that is the reason why India is not a perfect federalism as we see in the United States, and that is the reason why governor is also appointed by the central government, not elected. Okay, I hope you understand this. Now think about it. Even if he is the representative of the central government appointed by the central government, he cannot take decisions on whims and fancies or on his own discretion. The governor has to take decision on the advice of, aid and advice of the Council of Ministers of the state. Okay, as the Council of Ministers of the state. Any decision which is taken by the governor is taken on the aid and advice of the Council of Ministers of the state. Although several discretion are given, such as discretion to send a particular bill for the assent of the president, he can reserve a bill for the assent of the president, those are other matters, but in general terms he has to work on the aid and advice of the Council of Ministers. But does he do the same when he is acting as the Chancellor of the universities? नॉर्मल बिजनेस करते समय, कुछ भी बिजनेस हो, कोई भी डिसीजन मेकिंग हो, किसी भी चीज पर काम करना हो, he takes the aid and advice of Council of Minister. Okay, but as a chancellor of a university, does he take or work on the aid and advice of the Council of Minister? Now this is the question. Universities are of two kinds in India. Generally, if we see central and state, there are also deemed university, other sort of university, but in general we are watching it. Now, central university like JNU, okay, like Delhi University, like the central universities in several states. Allahabad University is also a central university. Similarly, Banaras Hindu University, those are also central university. The president is a visitor here in these university. These university does not have much to do with the governor of a state. But when it comes to the universities which are looked after by the state government, such as any university of your particular state, you can pick up any university. So this Meerut University has now become the Chaudhry Charan Singh University. This is a state university, okay, maintained by the state. Who is the chancellor here? The chancellor is the governor of UP. Okay, similarly, Kolkata University or Jadhavpur University. Kolkata University, who is the chancellor here? The governor of West Bengal. So what are the functions of governor as the chancellor? Now, he has overarching power. He has too much of power when he acts as the chancellor of the universities. He can appoint the vice chancellor. He can do so many other things, and most of the things done by him are not on the aid and advice of the Council of Ministers. He acts on his own discretion. The governor, as the chancellor of the universities, acts on his own discretion. Now this raises several important questions. One on federalism, that where is the state government here? The university is maintained by the state government, but the whole power lies in the hand of governor, who is the representative of the center. So one issue of federalism. Second issue of political interference. There is too much of political interference. People who does not have anything to do with education have been made the vice chancellor. The appointments in the universities of different departments, the deans and everything else also sometimes are done by political considerations. At the same time, there are other issues involved here, such as the governor himself may have no background in education but becomes the chancellor of a university just because he is the governor of a state. So those are important issues we are going to study in this video. Let's come to the next slide. This was the news of The Hindu. The governor's role as the chancellor of state university has become politicized, undermining university autonomy and causing governance issues. So it is also the issue of autonomy of a university. Can it act on his own or under the representative government, the representative of the central government? Now think about a situation where the party in the center is different from the party in the state. The university is the basis of political activities, and the influence of the central government through governor is huge in the state universities, just because he is a governor. So also the issue of autonomy and governance issue come into play. This becomes a hindrance in the delivery of education in the state. Okay, similar thing. Now let's come to the next slide and see. So the context is recently the governor's role as chancellor of the state university has sparked debate due to increasing political interference, undermining autonomy of the university and the governance issue. Now this particular model has been inherited from the British government. If you see the British government at the before the commencement of the constitution or before the independence in India, in 1857 this particular system has started, that the governor of those regions, especially the regions of Calcutta, Bombay and Madras, were made the chancellor of the universities. Why? In order to have control over these universities, the control of the British government, the governor of these particular presidencies were very powerful figures, and they wanted total control over whatever activities which are happening in the universities, which can become the ground for revolutionary activities in that period. And for that reason, that simple reason, governor was made as the chancellor of those universities and in those presidencies. But that particular system has continued in the modern India also. Okay, so this is a borrowed system. After independence, colonial model was adopted without reassessment, leading to governance issues. तो ये बहुत पुराना इशू है, ये जाता है पोस्ट इंडिपेंडेंस में. So challenges क्या हैं with the current system? Politicization. From 1947 to 67 there was no issue. Governor only acted on the aid and advice of the Council of Ministers. The quality of people who were becoming governor were also good in the Nehruvian era. They were ceremonial figures with the real power in the hand of chief ministers. But after 1967 things have changed. With the coming of Indira Gandhi, things have changed. The centralization of power started to happen, and it has also affected the governance of universities in India. Attempts to amend university law to replace the governor as chancellor have failed. Why? Because governor either blocked it or referred the amendment to the president, who does not allow such a change to happen. So this has been happening in the country from a long run. Governor's dual role. So acts on the aid and advice of the Council of Ministers under Article 163, we have already seen, and as a chancellor when he acts and advise without the Council of Ministers on his own discretion. So the view of the court is, Supreme Court says that the present system where the governor is the chancellor of the universities must continue. This is the point of view of the court. The implications can be the governor has wide significant authority over university matters, such as appointing vice chancellor. This is important. It appoints the vice chancellor, nominates the member, nomination of member to the university bodies, okay, which usually led to conflicts, particularly in the opposition-led state, as governor bypassed state government, undermining the university autonomy. So these are several issues: delays in appointment, inadequate qualification of governors. These are all issues which are concerning the governance in the universities, because the governor being the chancellor. So political appointments are done several times. Staff shortages are there, stalled projects are there, and postponement of the awarding of degrees. This is another issue, that if you have to get your degree in 2025 because of the some issues happening between the governor and the state government, your degree is given after 2 years. What's the meaning? You have wasted your 2 years. So several governance issues, several real core issues are happening, and the need of the reform is very much urgent. So there are several studies, commissions have came up and said, like the first Administrative Reform Commission has criticized that system. Sarkaria Commission have said that over 60% of the governor are active politicians. Similarly, Ashok Pandey's study have said that 52% of the governor are politician, whereas 26% retired bureaucrats and 22% came from different categories such as bureaucracy and armed forces. Now, how can you actually appoint politicians who does not have a real experience in education as the chancellor of a university? This is just like appointing an administrator or a bureaucrat or a politician as the chairman of the cricket board, which happens throughout the world. Does not have much knowledge of the game, but still is the chairman. So this debate has been going on in country for too long, and it has entered in the arena of education also. Increased political interference, federalism, we have already seen this thing. Now, this is a very important distinction. What happened when president acts as a visitor and governor as a chancellor? In appointments and other things, the president functions through the Ministry of Education and consults with it for appointment of vice chancellor, nomination of member to the university bodies and approval. So the president, having no discretion here, actually acts on the aid and advice of the Council of Ministers. One of the ministries here, Ministry of Education, gives advices to the president to act in a particular manner when it comes to the appointment of the vice chancellor, appointment of people to different bodies in the universities and other things. But what happens here? The governor acts unilaterally, performing all these similar functions: appointment of vice chancellor, nomination of member, all these functions he acts unilaterally, not on the aid and advice. He does not have his own advisors also for this thing, and has nothing to do with the Ministry of Higher Education in the state. Approval of statutes. What happens here? Central university law requires the statute along with other types of delegated legislation called ordinances and regulations to be laid before the parliament. So any act which is brought for the central university has to be laid in front of the parliament, but no such thing is there. The state university law does not mandate it to be kept in front of the state legislature. So you can see the distinction here and the problem, which is too huge, the interference in the system of governance of universities. So there are few proposed models which can happen. One of the models says that the governor must act as ceremonial chancellor, that he is just a chancellor, and the aid and advice of the Council of Ministers becomes all important. He does not have the discretion or does not work unilaterally as the chancellor. Second model is the chief minister as the chancellor, but the problem is this will politicize the post to a great extent. It will become a problem. Then state appointed chancellor, that state appoints somebody who has deep knowledge in education, who has been attached with the field from too long. This is a very good suggestion. Elected chancellor, it is done in several countries such as UK, where the chancellor is elected. There is a electoral college consisting of university bodies and alumni who elect the position of chancellor. Then the university appointed chancellor. The university appoints the chancellor. This happens at several places, especially in Melbourne and Birmingham. So these are few models. So again, why this is important for your examination is of the issue, because under Article 163 Clause 1, governor has to act on the aid and advice of the Council of Ministers, whereas acting as the chancellor of the university, he does not act on the aid and advice of the Council of Ministers. This results in few problems related with federalism, problem related with politicization of the post, and related with the governance issues and autonomy issues of the university. So this was the article, which is very important for your examination point of view, when something can be asked on the role of the governor and role of the governor as the chancellor of university in your prelims examination. I hope you will be able to give the answers through this video if you study this particular topic from this video. And this is all about the right to be forgotten. Now, you must have heard about the right to life and personal liberty under Article 21, right to privacy coming up of the present judgment of the Supreme Court in K.S. Puttaswamy in 2017. Right to privacy was interpreted as a part of right to life and personal liberty, but there is no such thing as right to be forgotten explicitly mentioned in Indian law. But this case is rising up. It has been going on from last 2, 3, 4 years, and it's becoming a voice that maybe there's a possibility that in future this thing can be included by the Supreme Court explicitly in the Article 21, right to life and personal liberty. So this is a news of The Hindu, which says that on the right to be forgotten from judicial records. So there are few cases which has happened in the past, and right to be forgotten is the ability of a human being to be forgotten from all the digital imprints they have. Coming of the digital age, your videos, your photos, whatever you have said, news about you, anything would be there on the internet. If you just go and search somebody's name on some or the other channel, the name of the person, the photo of the person will be reflected. Now that information will be of some use or not, does not matter. There are excessive information regarding one person which is there on the internet. Now companies like Google, Facebook, Meta, and so many other private companies such as YouTube, all these people, they use that information for the economic benefit of their company. At the same time, also for a greater use of structuring and organizing information. So with the coming of AI takes information from all the relevant sources which are available in the Google search. So how Google is organizing the information about you, or about somebody who is well known, or even about somebody who is less known. So they do use your personal data to do all those things. There are heavy machines to do all those things, and hence your personal information is needed. But the point is, what if you just want to be forgotten? Whenever somebody types your name, let's say Mr. ABC or Mrs. XYZ, and nothing comes up. Being a human, you just want to go and live in Himalayas and meditate and forget about life, and you just don't want anybody to see what you do, what have you done in the past. That is your right in a way. Now we are talking about life and death here. We are talking about right to life and right to live with dignity. We are also talking about right of a dignified death. Okay. We are also talking about right to die. So why not about right to be forgotten? It's more simpler question than a right to die. So let's see what is there in this particular article. So right to be forgotten generally refers to the ability, to have one's digital footprint removed. Okay, such as articles, videos, photographs, they all get removed and erased so that it no longer appears in the search engine. It seeks to balance right to privacy under Article 21 with freedom of expression and public's right to information under Article 19(1)(a). Now, it's important. For example, you rent your house. Somebody comes up who says, I want your house on rent. Or maybe you run a company and somebody comes up with their CV to ask for your, for a job in your company. Now you will do a little bit of background check, and that background check you find out that this person, some case is going on, he has done some cognizable offense, and the court is in cognizance, and the case is going on, and the kind of activity which this person has committed, you become a bit of fearful or maybe not comfortable to keep the person or give the person your house on rent, or keep the person in your company as an employee. What will you do in that situation? So the point is, your decision making is also influenced by your right to information under Article 19(1). Okay, right to information. a act has been passed, Right to Information Act, although this is about a particular private person's information here, and that is the reason why right to privacy jumps into the context. So this is the fight between right to privacy versus right to information. Okay, your freedom to know about a person, to do background check about a person. So then one American citizen who has visited India and got fixed into this NPDS case, although he got acquitted from the court, from the legal system, but when he went back to the United States, completed his study, he found himself not getting any job. He was not employable at all. Why? Because of the simple reason that companies did the background check and they found that there is some kind of case going on against him and nobody wants to employ such a person. But think about a situation, you have done something and you went to the jail because of it, and you were there in the imprisonment, completed your period of imprisonment for whatever number of months or years, and then you come out. You were the first time offender and you do this solemn resolve with yourself that I am not going to commit such a crime again or not going to do such a thing again ever. But you pay, not through the imprisonment, but you pay because of the information available to the person about that imprisonment, and that payment which you pay is far more longer than that period of imprisonment which you were there in the jail. Think about a situation, where you just cannot get rid of your past. So it is very important to understand this concept of right to be forgotten. So legal background as such, there is no explicit mention, but right to privacy is something, and which it's a broader umbrella. Right to life include right to die with dignity. Similarly, right to privacy also includes right to be forgotten. Digital Personal Data Protection Act of 2023. This act also does not explicitly mention right to be forgotten, but includes a right to correction and erasure. Right to correction and right to erasure of the personal data. And it has happened in some or the other places where the court have asked the particular private company such as Google or Facebook or Meta or WhatsApp or whichever company, Twitter or X, to remove a particular information about a particular person because that was not correct. It was proved otherwise in the court of law that Mr. ABC, and there is information available about this person was of a particular kind, but none of that information is correct, and that is the reason why court ordered the erasure of the information or the correction of the information about this person. That is possible and that has happened. There are examples there. See, the root of this right to be forgotten is found in the French jurisprudence, and there was this case of Google Spain. This is known as the Google Spain case, which happened in the European Union, and the judiciary of the European Union ruled in favor of removing outdated, irrelevant, excessive personal data. So it also makes the server lighter, isn't it? Too much of data is there which is of no use at all to anybody. It must be removed. The data is in making. Every day it is produced. Every day, every moment. Now what we are doing here is producing data. Somebody may have a copyright on this, or the one who is creating it has the copyright on this, or the owner has a copyright on this. But after some time this data may become irrelevant and of no use. What is the meaning of putting such a data on internet? Okay. Similarly, the information which is there on internet about a person can be negative and can be positive. Of course, a person doesn't want the positive information to be removed, but surely he should have the right to remove the negative information. It established the Search Engines Act. So this is one other thing which was done. So key Indian cases, if you see Zulfiqar Ahman Khan case, removal of Me Too articles for temporary purposes. Supreme Court has ordered to remove his Me Too article during the Me Too campaign. Then another American citizen case which we have already discussed, the person was acquitted but he has to face discrimination in the society, does not get the job, he was not employed at all because of the past case on him on which he was acquitted. He was not imprisoned. इस बंदे को छोड़ दिया गया था. That simply means the charges which were put on him were not proved and the person was left. He can go, but just because there was a case on him, he has to pay for that. He did not get a job because of the background search which the companies can do. Union of India, SK versus Union of India case, removal of accused name from online database, and this Karthik Theodore case, conflict of judicial transparency and privacy. These are few key cases which happened in India. Now, conflict with freedom of speech. Now, this is, we have already seen. On one hand, we have the privacy thing, and on the other hand, in the name of public interest and transparency and justice, right to information is there, and it needs to be balanced in some or the other way. Madras High Court's view is that the public access to judicial records serves public interest. This is one view. Supreme Court's pending decision to clarify the conflict. So there are, challenges to enforcement, challenges in enforcement. See, there will definitely be technical issues. If you want to remove some information, the company has to go through so many things to remove the information totally from their server. So definitely there will be several technical challenges and the lack of clear legislation. Of course, that is one of the great challenge here. So what is the way forward? Supreme Court's pending decision, it is going to come and it is going to show us the way forward. This is one thing. Need for a comprehensive legal framework needs to be done by the Parliament. This case, judiciary will look after it, the Supreme Court, but this needs to be done by the Parliament to define the right, privacy rights, freedom of expression and public interest very clearly, so that a balance can be drawn between privacy on one hand and right to information on the other hand. Empowerment versus censorship dilemma. This will also be solved if the Parliament comes up with some comprehensive law. So this particular thing is evolving in India. Right to be forgotten, it's a good thing. A clear legislative framework is essential to balance privacy and freedom of expression, to provide consistent legal guidance. Supreme Court's decision is anticipated to be a landmark decision. So that is the end of the video. That is the information we have till now regarding the right to be forgotten. Right to privacy has been considered as a very important right by courts, also in India by the Supreme Court. In several cases, right to privacy has been given the primacy over right to information, that in the public interest, some information needs to be there in the public domain. But if it is hurting or curtailing or abridging the right to privacy, then that particular information is also removed. So right to privacy has a very, very strong case in India now, in the modern society of India. And right to privacy, in a way also includes right to be forgotten. This is also evolving in the country now, and maybe in that pending judgment of the Supreme Court, we are going to see some or the other important angles related with right to be forgotten. For you, important about your examination is this right to be forgotten is not found anywhere in Indian law. explicitly, and this issue involves right to life and personal liberty, right to privacy, freedom of expression, a person's right to know, right to have the information under the freedom of expression and speech. Important topic which will be of a great use for you in your upcoming prelims examination of 2025, and this is all about the right to be forgotten. Now you must have heard about the right to life and personal liberty under Article 21, right to privacy coming up of the present judgment of the Supreme Court in K.S. Puttaswamy in 2017. Right to privacy was interpreted as a part of right to life and personal liberty, but there is no such thing as right to be forgotten explicitly mentioned in Indian law. But this case is rising up. It has been going on from last 2, 3, 4 years, and it's becoming a voice that maybe there's a possibility that in future this thing can be included by the Supreme Court explicitly in the Article 21, right to life and personal liberty. So this is a news of The Hindu, which says that on the right to be forgotten from judicial records. So there are few cases which has happened in the past, and right to be forgotten is the ability of a human being to be forgotten from all the digital imprints they have. Coming of the digital age, your videos, your photos, whatever you have said, news about you, anything would be there on the internet. If you just go and search somebody's name on some or the other channel, the name of the person, the photo of the person will be reflected. Now that information will be of some use or not, does not matter. There are excessive information regarding one person which is there on the internet. Now companies like Google, Facebook, Meta, and so many other private companies such as YouTube, all these people, they use that information for the economic benefit of their company. At the same time, also for a greater use of structuring and organizing information. So with the coming of AI takes information from all the relevant sources which are available in the Google search. So how Google is organizing the information about you, or about somebody who is well known, or even about somebody who is less known. So they do use your personal data to do all those things. There are heavy machines to do all those things, and hence your personal information is needed. But the point is, what if you just want to be forgotten? Whenever somebody types your name, let's say Mr. ABC or Mrs. XYZ, and nothing comes up. Being a human, you just want to go and live in Himalayas and meditate and forget about life, and you just don't want anybody to see what you do, what have you done in the past. That is your right in a way. Now we are talking about life and death here. We are talking about right to life and right to live with dignity. We are also talking about right of a dignified death. Okay. We are also talking about right to die. So why not about right to be forgotten? It's more simpler question than a right to die. So let's see what is there in this particular article. So right to be forgotten generally refers to the ability, to have one's digital footprint removed. Okay, such as articles, videos, photographs, they all get removed and erased so that it no longer appears in the search engine. It seeks to balance right to privacy under Article 21 with freedom of expression and public's right to information under Article 19(1)(a). Now, it's important. For example, you rent your house. Somebody comes up who says, I want your house on rent. Or maybe you run a company and somebody comes up with their CV to ask for your, for a job in your company. Now you will do a little bit of background check, and that background check you find out that this person, some case is going on, he has done some cognizable offense, and the court is in cognizance, and the case is going on, and the kind of activity which this person has committed, you become a bit of a fearful or maybe not comfortable to keep the person or give the person your house on rent or keep the person in your company as an employee, what will you do in that situation? So the point is, your decision making is also influenced by your right to information under Article 19(1). Okay, right to information. An act has been passed, Right to Information Act, although this is about a particular private person's information here, and that is the reason why right to privacy jumps into the context. So this is the fight between right to privacy versus right to information. Okay, your freedom to know about a person, to do background check about a person. So then one American citizen who has visited India and got fixed into this NPDS case, although he got acquitted from the court, from the legal system, but when he went back to the United States, completed his study, he found himself not getting any job. He was not employable at all. Why? Because of the simple reason that companies did the background check and they found that there is some kind of case going on against him and nobody wants to employ such a person. But think about a situation, you have done something and you went to the jail because of it, and you were there in the imprisonment, completed your period of imprisonment for whatever number of months or years, and then you come out. You were the first time offender and you do this solemn resolve with yourself that I am not going to commit such a crime again or not going to do such a thing again ever. But you pay, not through the imprisonment, but you pay because of the information available to the person about that imprisonment, and that payment which you pay is far more longer than that period of imprisonment which you were there in the jail. Think about a situation, where you just cannot get rid of your past. So it is very important to understand this concept of right to be forgotten. So legal background as such, there is no explicit mention, but right to privacy is something and which it's a broader umbrella. Right to life include right to die with dignity. Similarly, right to privacy also includes right to be forgotten. Digital Personal Data Protection Act of 2023. This act also does not explicitly mention right to be forgotten, but includes a right to correction and erasure. Right to correction and right to erasure of the personal data. And it has happened in some or the other places where the court have asked the particular private company such as Google or Facebook or Meta or WhatsApp or whichever company, Twitter or X, to remove a particular information about a particular person because that was not correct. It was proved otherwise in the court of law that Mr. ABC, and there is information available about this person was of a particular kind, but none of that information is correct, and that is the reason why court ordered the erasure of the information or the correction of the information about this person. That is possible and that has happened. There are examples there. See, the root of this right to be forgotten is found in the French jurisprudence, and there was this case of Google Spain. This is known as the Google Spain case, which happened in the European Union, and the judiciary of the European Union ruled in favor of removing outdated, irrelevant, excessive personal data. So it also makes the server lighter, isn't it? Too much of data is there which is of no use at all to anybody. It must be removed. The data is in making. Every day it is produced. Every day, every moment. Now what we are doing here is producing data. Somebody may have a copyright on this, or the one who is creating it has the copyright on this, or the owner has the copyright on this. But after some time this data may become irrelevant and of no use. What is the meaning of putting such a data on internet? Okay. Similarly, the information which is there on internet about a person can be negative and can be positive. Of course, a person doesn't want the positive information to be removed, but surely he should have the right to remove the negative information. It established the Search Engines Act. So this is one other thing which was done. So key Indian cases, if you see Zulfiqar Ahman Khan case, removal of Me Too articles for temporary purposes. Supreme Court has ordered to remove his Me Too article during the Me Too campaign. Then another American citizen case which we have already discussed, the person was acquitted but he has to face discrimination in the society, does not get the job, he was not employed at all because of the past case on him on which he was acquitted. He was not imprisoned. इस बंदे को छोड़ दिया गया था. That simply means the charges which were put on him were not proved and the person was left. He can go, but just because there was a case on him, he has to pay for that. He did not get a job because of the background search which the companies can do. Union of India, SK versus Union of India case, removal of accused name from online database, and this Karthik Theodore case, conflict of judicial transparency and privacy. These are few key cases which happened in India. Now, conflict with freedom of speech. Now, this is, we have already seen. On one hand, we have the privacy thing, and on the other hand, in the name of public interest and transparency and justice, right to information is there, and it needs to be balanced in some or the other way. Madras High Court's view is that the public access to judicial records serves public interest. This is one view. Supreme Court's pending decision to clarify the conflict. So there are, challenges to enforcement, challenges in enforcement. See, there will definitely be technical issues. If you want to remove some information, the company has to go through so many things to remove the information totally from their server. So definitely there will be several technical challenges, and the lack of clear legislation, of course, that is one of the great challenge here. So what is the way forward? Supreme Court's pending decision, it is going to come and it is going to show us the way forward. This is one thing. Need for a comprehensive legal framework needs to be done by the Parliament. This case, judiciary will look after it, the Supreme Court, but this needs to be done by the Parliament to define the right, privacy rights, freedom of expression and public interest very clearly, so that a balance can be drawn between privacy on one hand and right to information on the other hand. Empowerment versus censorship dilemma. This will also be solved if the Parliament comes up with some comprehensive law. So this particular thing is evolving in India. Right to be forgotten, it's a good thing. A clear legislative framework is essential to balance privacy and freedom of expression, to provide consistent legal guidance. Supreme Court's decision is anticipated to be a landmark decision. So that is the end of the video. That is the information we have till now regarding the right to be forgotten. Right to privacy has been considered as a very important right by courts, also in India by the Supreme Court. In several cases, right to privacy has been given the primacy over right to information, that in the public interest, some information needs to be there in the public domain, but if it is hurting or curtailing or abridging the right to privacy, then that particular information is also removed. So right to privacy has a very, very strong case in India now, in the modern society of India, and right to privacy, in a way also includes right to be forgotten. this is also evolving in the country now, and maybe in that pending judgment of the Supreme Court, we are going to see some or the other important angles related with right to be forgotten. For you, important about your examination is this right to be forgotten is not found anywhere in Indian law explicitly, and this issue involves right to life and personal liberty, right to privacy, freedom of expression, a person's right to know, right to have the information under the freedom of expression and speech. Relates to custodial deaths and what Supreme Court has to say on custodial deaths. Supreme Court has taken a very strict view on custodial deaths. It has set aside the cop's bail. That simply means a cop, a police officer, was involved in the murder of a detained person in the custody. That simply means there was a robbery which happened, and out of this robbery a person was arrested. Now this particular person was in the jail, in the premises of the custody, the police custody. Okay, there are two kinds of custody, always remember. Judicial custody, that simply means in the custody of the magistrate, and police custody, that simply means in the custody of the ऑफिसर इंचार्ज ऑफ द पुलिस स्टेशन. आपके जो लोकल थाने में अगर कोई बंद है दैट इज पुलिस कस्टडी, और बड़ी जेल में कोई बंद है तिहाड़ और दूसरी बड़ी जेलों में तो वो है जुडिशियल कस्टडी. सो अ पर्सन हु वाज इन द पुलिस कस्टडी, दिस पर्सन अक्यूज्ड ऑफ रॉबरी हैज बीन फाउंड डेड, एंड दैट इज द रीजन व्हाई दिस केस हैज अप्रोच्ड द कोर्ट. नाउ custodial death is a very serious crime. Now why? Simply because the person is in the custody of police. Police is the savior of people. They cannot kill people when the person is in custody. Rule of law has to be followed. That simply means if somebody is in custody, Article 22 applies. Article 22 says what? That a person needs to be taken in front of the magistrate within 24 hours, has to be given legal representation, and should be told the ground of arrest. Okay, but think about the situation, none of them is followed, or even if these things are followed and the person is in police custody and the person dies there, whose responsibility is it? It is the mandate of the state to protect people. Now it does not matter whether the person who is in custody, who has been allegedly arrested for some crime, now that is the person, or a normal other person. The state's mandate is to protect people. Now the person was not charged, or say was not given punishment by the judge or by the court. So until proven guilty, everybody is innocent. There is no meaning of any custodial death which can take place, and it should be taken very strictly, and Supreme Court has said this thing. Now in this particular case, what has happened? This person was found dead, and the police, there were several police officers who were charged with section 302 murder ki dhara, and a bail was given by Allahabad High Court to the cop. Supreme Court has set aside that bail. Okay, जब इलाहाबाद हाई कोर्ट से बेल मिल गया, so the brother of the deceased person went to the Supreme Court, और Supreme Court में जब केस को the court took the cognizance of the case, what happened? They have set aside the bail. That simply means they wanted the police officer to be in custody, because the mandate of the police officer, the duty of the police officer is not to kill people who are in custody, but to save them, to investigate them, not to kill them. That is very important, and something which has been done by the authority of the state, something like custodial death, something like death because of the torture the police inflicts upon the person on the custody. That is really very bad and sets a very wrong precedent, and that is why it can be considered as a heinous crime, not like normal crimes, and that is the reason why the bail was set aside by the Supreme Court. So let us see what is there in the slide. Supreme Court stands on the custodial death. What the Supreme Court says? It has a very strict approach towards giving bail to police officers who have been involved in custodial deaths. It emphasized greater accountability of the law enforcement. एक आदमी जब custody में होता है, so he is very vulnerable, he is not protected by anybody and he is surrounded by police officers. Now the point is, during interrogation or investigation, if you torture the person and you kill him even by chance, I mean that should not be permitted. Okay, there is nobody, no legal representative present there, no family member present there, nobody is present there, and not necessarily the person who is in police custody is the real accused or the real culprit. Maybe in the court it will be proved that the person was innocent. So the court has to take strict approach while dealing with the bail pleas of officer involved in custodial death. It aligns with the constitutional protection given under Article 20, 21 and 22. We are going to see what are these and other human right provisions. So apart from Article 20, 21 and 22, there are few protections, legal protections which are given against the custodial death. Indian Penal Code of 1860, punishment for murder if police leads to death, police action leads to death. Section 302 of murder is something you will be charged with if you are a police station and under your command somebody has died in police custody. Code of Criminal Procedure CRPC 1973, it mandates judicial inquiry in custodial death. Similarly, National Human Rights Commission, State Human Rights Commissions monitors and investigate cases of custodial violence. SC/ST Prevention of Atrocities Act, if such a thing happens with a person who belongs to SC and ST communities, additional protection is given, additional safeguard is given under this particular act. It becomes a very grave issue if a person from SC or ST community dies in custodial death. So additional prevention or safeguard has been given to this particular communities through the Prevention of Atrocities Act. Right to compensation, Supreme Court mandates compensation to victims' family, and United Nations Convention against atrocities, okay, against torture. India is a signatory but has not ratified it. So this is important legal safeguards which are given against the custodial deaths in India. Now there are several cases of the Supreme Court and the cases of other courts also which are key guidelines in the area of custodial death. For example, DK Basu case of the West Bengal, Article 21, right to life and personal liberty, extends to victims and under trials. This is important to understand that the court has invoked Article 21 in order to tell that custodial deaths are not tolerated in this country, because Article 21 extends to convicts and under trials also. Article 21 is not only about human beings who are free, but also if a person is in detention, has been arrested because of something, Article 21 applies to all. It applies to citizens, it applies to aliens, it also applies to people who are under trial and in custody. Guidelines on arrest has been made through this particular case. The guidelines on arrest and detention, such as medical checkups and legal representation, etc. There was another case in the state of Odisha where this liability was established for custodial death, that somebody has to be liable. The responsibility has to be there on somebody, either the officer in charge of the police station or somebody who is directly responsible for custodial death, but there has to be some sort of liability on custodial deaths. We cannot tolerate these kind of deaths in our country. We are a law abiding country. The custody, the police custody is granted only for interrogation and further investigation, but not to torture the person to death. This is important to understand. It infringes several fundamental rights. We have already seen Article 20, 21 and 22. It is recognized right to compensation. We have already seen this. point. So there is a difference between police custody and judicial custody. We are going to see this. So what is the purpose of police custody? To prevent further offences based on complaints or information. And here judicial custody, detention ordered by magistrate for investigation. Sometimes the police custody is also given for investigation and interrogation. For example, a case is going on, the charge sheet is yet to be filed, and the police needs to do further interrogation or investigation on the particular topic, on the particular issue, and they can go to the court and ask for police custody of the person who has been detained in the judicial custody. So if the court permits maximum 15 days, police custody can be provided, not consistently. It can be like 2 days at one time, 5 days at another time. So police, it helps the interrogation and investigation of the police, because they can actually ask the person few questions which can help them in reaching to the truth of the case very easily, and that is the reason why police custody has been provided. But that cannot be the reason to torture a person. Now it is in the direct control of the police. In police custody, accused is under the magistrate's custody. Now when you say magistrate's custody, that simply means not in the court of the magistrate or not in his house. That simply means in jail, a bigger jail such as the Hard jail. Okay, that's not a police station, that's a proper jail. Interrogation, police can interrogate without court's approval, because court has already given the approval. See, two type of police custody can happen. If a person is arrested on a cognizable offence, the person has to be produced in front of the magistrate within 24 hours. Okay, within 24 hours. So if a person is arrested, let's say at 11 a.m. today, then the person has to be presented in front of the judicial magistrate by 11 a.m. tomorrow. Okay, within 24 hours. So for these 24 hours, the person is in police custody. Okay, of course the police can take the person on the same day into the judicial cognizance, but the point is the maximum limit of 24 hours is given. So for those 24 hours, the person is in police custody. Now if once the person goes to to the judicial magistrate, and judicial magistrate in some or the other way sends him to jail, and then for interrogation or investigation the police needs him back in the police custody, they can request the court for police custody again, and then the person comes back to the police custody for maximum 15 days, not more than that. And those 15 days are not necessarily continuous 15 days. It can be in the chunks of 2 days or 5 days at one time and 5 days the other time, as per the need of the police for interrogation and investigation. Okay, so these are two kind of police custodies I told you. So in whichever way, if the person is in police custody, does not matter before these 24 hours or after that, after the court's permission, or even before the presentation of that person in front of the judicial magistrate, if the person dies in police custody, it is the responsibility of the investigating officer, it is the responsibility of the police in charge of the police station, the officer in charge of the police station, to look into the matter, and the liability is very much fixed and it is counted in the heinous crime. It is important for us to understand. The location is the lockup, police station lockup, and here the jail or police custody per magistrate's order. Okay, mostly it is jail. The duration is, so for example, sometimes there is no jail available in that particular district, so magistrate can ask the police to keep the person in their own custody in the lockup. Okay, now that is the prerogative of the magistrate. Somewhere the person has to be kept, and if there is no big jail or the condition is not appropriate for the person to be taken to the bigger jail, the magistrate can take the issues in their own hand and request the police to lock up the person in the police custody. That also will be considered as judicial custody, because that is coming from the permission of the judicial magistrate, and duration is maximum 24 hours before magistrate and extendable up to 15 days. We have already seen. Judicial custody is for 90 days and 60 days. In the cases of 90 days, it is for serious offences, and in the case of 60 days, it is for lesser serious offences. Then the charge sheet has to be filed in the court. Now, these three important articles are involved, and they will be very important for your upcoming prelims examination. Article 20, 21 and 22. Now, many people knows about Article 21, which is right to life and personal liberty. Many things are involved. This article has become mammoth. It has taken, very huge twists and turns over a period of time, and so many things are included. The recently included thing was right to privacy. But this article is a very, very big and a huge and an important article. Custodial deaths, the freedom of life and personal liberty, all these things becomes the part of Article 21. That simply means if a person is in custody, okay, and in some or the other way his life is threatened, he has the right to approach court under Article 21. Even a person who is under detention. That is very important for us to understand. What right does a detainee have? He has this right, Article 21, right to life. Nobody can take his or her life except by the procedure established by law. That simply means if the court orders, after the case is run, after the judgment comes and the judgment says that the person has to be hanged till the person dies, a death penalty is given to the person. That is the procedure established by law, and according to the procedure established by law, few things are taken up. The life of a person is taken, but not without the court's permission, not without the full case or the judgment. After the judgment these things can happen, but not before that. Before that, if something like this happens, that is simply infringing the fundamental right, Article 21 of the person, right to life and personal liberty. Now, Article 20 is also important because it gives protection from arbitrary or excessive punishment. Three very important things involved here: post de facto law, double jeopardy, and self-incrimination. Self-incrimination and post de facto law, everybody knows that in criminal cases the court or the punishment through court cannot be given on anything done by a person in a backdate. It is always prospective. The criminal cases, the criminal charges are never retrospective. For example, an act which is punishable now and was not punishable 2 years before, and a person has done that act 2 years back, okay, the person cannot be charged today for the same act. Similarly, double jeopardy is that the same person cannot be punished for the same crime twice. If a person has been given the punishment because of one crime, that is okay, that is done. The person now needs to be set free. Similarly, self-incrimination, nobody should be made should not be asked by the police to give information about his own sort of incriminating oneself. I hope you understand the meaning of it. That the person must not be in any way, shape or form should be forced by the police to give be witness against himself. Now that is the correct statement. Nobody can be witness against himself. That is what is self-incrimination means. That is not allowed under Article 20. Now Article 22, protection against arbitrary arrest. This is very important. Just before a person is getting arrested, or the person who is getting arrested, the person needs to be told about the grounds on which the person is arrested. The person has to be given legal representation to defend himself, and also if there is a case of preventive detention, there also a legal representation has to be made, and the ground needs to be communicated and immediately communicated to the person who has been taken into custody under preventive detention. So there are two kinds of detentions: punitive detention and preventive detention. Preventive detention is covered under Article 22 of the Constitution. Punitive detention simply means that the court has taken the cognizance and given the punishment after the trial. Okay. Conviction through due process of law. Similarly, what we were discussing a few minutes back, that if a person has been given death penalty after the trial, after the due process has been followed, that is very well permissible, because punishment is the basis of the stability in the society. The punishment has to be given to person who are doing heinous crimes. Okay, they cannot be left alone, they cannot be set free. So any kind of punishment which is given, two conditions are important: trial and following of the due process. But if both of these are not done and the person dies in custody, now that is upon the state to check. Preventive detention, we have already seen, covered under Article 22. On the suspicion that the person may do something which may hurt the public order, which may be against the foreign affairs or relations of India, then the person is detained. So again, this is important for a prelims examination. That is the reason why we are reading it. Legislative powers over detention. So Parliament can legislate on preventive detention on these grounds: defense, foreign affairs and security, national security. These are covered under the union list. So preventive detention, laws can be made by Parliament and the state legislature both, but on different matters. Of course, the laws made by the Parliament are far more broader than the laws made by the state legislature. When it comes to state legislature, they can only make laws on preventive detention on the basis of security, public order and essential services, but the Parliament can make on these and defense, foreign affairs and national securities as well. So Parliament power to extend the detention. So if a person has been detained for, let's say, for 3 months, the person has to be set free. But if a committee can be made, and advisory committee is there, if they advise that the person's detention can be extended, then it is extended. Again, it is a due process of law, and all kind of law in these matters are made by the Parliament. The extension of the preventive detention, any law which has to be made, are made by the Parliament, and Parliament has also came up with a amendment, 44th Amendment Act in 1978, which has given reduced the detention by the advisory board review from 3 months to 2 months. That simply means after 3 months, a person's plea has to go to the advisory committee, and then the advisory committee decides whether the person should be kept in detention or should be set free. So 44th Amendment has reduced this 3-month period to 2-month period, but this has yet not been enforced. Okay. So that simply means that today's status is that after the 3 months of detention, the plea of the person goes to the advisory board, and it is the advisory board which decides on whether the person should be kept in detention or should be set free. So Supreme Court is very strict on this matter of custodial death. It is very strict on the matter of accountability of the police officers and the law enforcement agencies. At the same time, legal safeguard and constitutional rights are given to the people of India so that they can protect themselves against custodial torture and custodial death. So there is a need to ratify the United Nations Convention against torture. So thank you very much for joining me in this video. Simply, we have seen 2 to 3 things which are very important for our prelims examination. One thing is Article 20, 21, 22, few legal provisions, few cases which helps the people against custodial death, which in the by the Supreme Court has been declared as a heinous crime because the state is involved in killing a person in custody. This will be important for your upcoming prelims examination. Supreme Court has said something about the anticipatory bail and also about something related to the SC/ST Act. So not every insult against SC/ST persons can be considered as an offence under the SC/ST Protection Act. We all know SC/ST Protection Act is there of 1989. So let us try to understand this whole concept of what has actually happened. Now the key judgment is there was a two-judge bench which was constituted and said that whatever bar section 18 puts on section 438 of CRPC will not be available if there is no prima facie content available to point out that a commission of an offence has been done. Okay, now let me simplify all this. Anticipatory bail. This is a very important provision for civil liberties in India. Anticipatory bail simply means that before you get arrested, the court grants you bail. इससे पहले कि पुलिस आपको पकड़े अरेस्ट करे, अगर आप कोर्ट पहुंचते हैं और कोर्ट if they give you or grant you the anticipatory bail, of course not in heinous crimes, not in cognizable of, can be done in cognizable offences, but of course not done by court in special laws like UAPA or in heinous crimes. But anticipatory bail can be given because sometimes a person who is arrested not necessarily have committed the crime, and that is the reason why anticipatory bail is given. And anticipatory bail is one of the most important aspect of civil liberties in India. So the provision of anticipatory bail is given in section 438 of CRPC and the new BNSS Act section 482 in BNSS, Bharatiya Nyaya Suraksha Samhita. Now anticipatory bail can be given under these two sections. Now section 18 of the SC/ST Act, it bars the anticipatory bail given under section 438. That simply means any offence is committed where an arrest has to be made or allegations are made under section of the SC/ST Acts. According to section 18 of that particular act, anticipatory bail cannot be given to the person. So simply means that if a person, if anybody commits any crime against a person from SC/ST community, anticipatory bail cannot be given to that particular person. Okay, I hope you understood this. One more thing, court said that the bar on anticipatory bail is allowed when section 41 of CRPC is applied, which is read with section 60A. Now section 60A says that any arrest of any person made by the police officer has to be made according to law, and in this case the law is CRPC, according to this code as it says. Section 41 says that the arrest of any person can be made by the police officer in cognizable offences without warrant. So section 41 gives the power to the police officer to arrest anybody without warrant. But if you read it with section 60A, that the arrest has to be made according to the code, according to CRPC. So in these cases, the anticipatory bail can be barred. But in all other cases, even if the allegations are made under the SC/ST Act, there has to be some sort of prima facie material available for the anticipatory bail to be cancelled. कहने का साफ मतलब है कुछ तो होना चाहिए ये चीज देखने के लिए कि सही में कोई क्राइम कमिट हुआ है या नहीं. अगर सिर्फ एक कंप्लेन के बेसिस पे किसी को एंटीसिपेटरी बेल नहीं दी जा रही है, सो इन वन और द अदर वे इट इज इन्फ्रिंजिंग द सिविल लिबर्टी ऑफ द पीपल. So I hope it clarifies your doubts around this subject. So section 18 of SC/ST Act, as we have seen, it excludes the anticipatory bail under section 468. Supreme Court ने जो clarify करा वो क्या है? Courts must verify the allegations made. कोई भी allegation which are made against a person under SC/ST Act of 1989 has to be confirmed by the courts. Okay, whether that allegation is true or not, some sort of material which proves the allegation correct has to be presented in order for the anticipatory bail to be cancelled. Not automatically it will be cancelled. ऐसा नहीं है कि section 18 में लिखा हुआ है कि section 438 of CRPC will not be applied to the cases of the SC/ST Act, तो anticipatory bail लागू ही नहीं होगी but उसके पहले कोर्ट्स वेरीफाई करेंगे. कोर्ट्स ये वेरीफाई करेंगे कि whether there exists some material which proves the allegation or not. अगर allegation prove ही नहीं हो रहा है, if there is no material available, then the anticipatory bail can be given. This is a step towards civil liberties and upholding of civil liberties. Now, this was the case. Sahajan, he was, who is he? Now, he was a Malayali YouTuber news channel speaker, and he has said something derogatory against the CPM leader and the Kerala MLA PV Srinijan. So he said something which was derogatory, which is considered derogatory, but he was given the anticipatory bail. Why he was given the anticipatory bail? For the same reason, no prima facie material is available. If the prima facie material would be available, then the anticipatory bail would not have been given. Very simple to understand. So Supreme Court का decision क्या है? It granted the anticipatory bail as prima facie case was not strong. There was no material which can be considered as an important material to lodge a complaint against that person. Or even if the complaint is lodged, further investigation or interrogation is required, but the anticipatory bail should be given. So what is anticipatory bail? We have already seen section 482 of the BNSS and 438 of CRPC allows a person to apply for bail before arrest. Before a person gets arrested, you can be freed. Described as an important aspect of personal liberty. We've already seen this. It protects the individual from unjustified humiliation and harassment. So many important things are happening because of the anticipatory bail. It's a very important provision of law. Court must balance rights of the accused and victims. So a balance has to be created. Anticipatory bail should not, reflect some sort of injustice happened, some heinous crime has happened, or any special law under which a person has been booked and the court gives the anticipatory bail. That is also not good. So bail is rule and jail is exception, but in heinous crimes, but in crimes related to anti-terrorist activities under UAPA, that thing is not accepted by the courts. Their court says that the bail is an exception because the acts done are anti-human and inhuman. So conditions for granting bail, what are the conditions? That there has to be some reasonable apprehension in the mind of the accused that the arrest can be done at any point in time. Several conditions are that they must cooperate with the police in investigation. Along with that, they cannot leave the country without telling or without informing the police, and bail can be cancelled at any time. They can be called back to custody, police custody or judicial custody at any point in time by cancellation of the anticipatory bail. So these are few conditions which are available for the anticipatory bail to be issued by the courts. Types of bail under CRPC. Very simple. Regular bail which you get after the custody, means a person is in custody for n number of days and then the person applies for bail and he gets it. Okay, the person must not be kept in jail if there are too many days still left in investigation, or the investigation has to be too long and charge sheet is yet to be filed, which will take so many days, and the person has not committed some heinous crime, at that point in time bail can be given, and that bail is regular bail. Interim bail is the temporary relief which you get just before the main bail application is in front of the court, and anticipatory bail is the pre-arrest bail. We have already seen this. So there are few cases in state of Rajasthan versus Balchand in 1997. The court said that bail is rule and jail is exception. In the trial, if the person does not have the capacity to influence the trial in his favor, okay, and the person has not committed some heinous crime which he may repeat if he is set free, at that point in time the person should be given bail, because he has not been sentenced to imprisonment. The trial is still not complete, the judgment has yet not came, and the person in trial may be proved and can be proved as innocent. So why to keep the person in jail? There is no meaning of doing it, and that is the reason why the person should be given jail, and jail should not be a rule but should be an exception. But jail is an exception in cases which are anti-terrorist or which are heinous. Shift burden of proof onto the accused, and bail denied if prima facie evidence exists in UAPA, Unlawful Prevention Act, Activity Prevention Act. So the conclusion is that if all the ingredients of the offence exist, anticipatory bail can be given, and it ensures the protection of the SC/ST community without the misuse of the law. Several times misuse of the law is also done just to harass a person, and there are provision in law such as section 18 we have already seen, which bars the anticipatory bail given under section 438 of CRPC, but that is no more applicable after the court's interpretation that in order to give anticipatory bail, the court must verify the allegations, and if there is a prima facie evidence or prima facie material available to prove that the allegations which are made are very much true, then the anticipatory bail will be cancelled, or else the anticipatory bail will be given to the accused. What is the significance? It upholds the fairness in criminal justice system. So thank you very much for joining me in this video. There are few important provisions such as Article 21, few sections of CRPC which are very important, and the article on civil liberty, if you see, right to movement, right to have free speech and expression under Article 19, which are very important here, because anticipatory bail is an important provision of civil liberty, and anybody can be arrested on any allegations made by somebody. Now it is upon the court to actually investigate the matter in such a way that the truth comes out, whether the allegations which are made are true or not. There must be some material available, and the police authorities, the authorities which are making the arrest must also come up with these kind of evidences, so that a person who is innocent is not harassed as per the law. That is what is rule of law in simple terms. We have come up with a very important topic again. It relates to the legal provision for the convicted politician. तो अगर एक पॉलिटिशियन को जेल हो जाए तो फिर क्या उसको चुनाव लड़ने के लिए दोबारा राइट है या नहीं है? Now recently in Supreme Court a petition was filed, and in that particular petition the petitioner has said that there has to be and there should be a lifetime ban on the politician, and he was speaking on the ground that if the government job is not allowed to a convict, why they should be doing lawmaking after they are convicted of some sort of crime. So seeks a lifetime ban on the convicted person. It was a petition which was filed from contesting election. That simply means if you go to the jail for any crime committed once, you will not be able to fight election throughout your life. This is just a petition. This is what they have said in the court. The court has not given the judgment yet. Now, the petition argues that if such individuals are ineligible for government jobs, okay, they should not be eligible for lawmaking. Fair enough, but what the Supreme Court has, what the center has said in this matter is very important, that center opposed this, and it said that punitive action, the penal action are finite, they are not infinite. You cannot punish a person after they had completed their imprisonment, they have completed their punishment. Okay, this will be against the civil liberty, this will be against the a mechanism where you want to give chance to a person to transform himself. Okay, and especially in the arena of public service, the politicians, they are very important for the country, and if they learn from their own mistakes, whatever they have committed, and now they are a transformed person, that whatever they did will not be repeated again, they solemnly resolved to do no mistake in future, no crime in future. It will be a very helpful scenario for the country. But a lifetime ban on politician will not be good. And looking it from the point of view of civil liberties also, you can only punish a person for a particular period until and unless they are given death sentence or life imprisonment, only for a particular period, and after that they are free. We have done a video on right to be forgotten, because there are too many people whose identity are revealed on internet, their pasts are there on the internet, and even if those people who went to the jail and came out from the jail, if they go out to seek a job, they are not given job just because they have a history of such kind of criminal activity in their life. So this is a very important issue. We will see some provisions, constitutional provisions also to support our arguments. One ADR report said in 2024 that there are 46% of member of parliament who face criminal charges. This is too much, okay, and 31% of them are charged with serious crimes like rape, murder and kidnapping. Law Commission and Election Commission have said in 2019 and 2014, they have suggested that individuals must be disqualified who are charged with punishment for over 5 years. Now these are recommendations and suggestions, not necessarily they will be accepted by the government. The current petition have said this, we have already seen this. Now coming to the legal provision, Representation of the People Act 1951, there are provision related to the Representation of the People Act. We will see section 8, and in that section 8 subsection 3 says that if any person is convicted for more than 2 years, there will be a ban of 6 years the moment he comes out of jail. That simply means if a person was convicted in the year 2012 for 2 years, so he is going to be in the jail from 2012 to 2014. For the next 6 years, that means 2020 till 2020, for the next 6 years, this person will not be eligible to fight election. Similarly, section 8 subsection 1 says the same thing, but in the matter of heinous crimes like rape or crimes under UAPA Act, anti-terrorist activities and all, Prevention of Corruption Act, if a person goes into the jail, from there on, when he completes his punishment, from there to 6 years, he will not be allowed to fight elections. These are very important provision. No contesting of election for the candidate for 6 years after their release. Section 11 gives the power to Election Commission to reduce or remove the sentences or disqualifications. So there was also a section, if you see, we have read 3 section, important section, section 8 and subsection 3, subsection 1. Now we also have subsection number 4, which was struck down. What did this say? In this Lily Thomas case of 2013, it prevented convicted legislators from continuing without immediate disqualification. That simply means if a person who is a politician is convicted of a crime, they can continue to hold their position. They can continue to be the member of parliament or the member of legislative assembly or the minister or whatever without being disqualified, even if they are convicted. This was struck down by the Supreme Court in 2013 in the Lily Thomas case, a very important case which is seeking for the decriminalization of politics in India. So this article is totally about the decriminalization of politics in India. We see too many of the criminals coming up to become politicians, and they do become politicians because of the kind of money they have. They can fund themselves in the elections. And in today's India, the election costs too much. If a person has money and he can back himself, and the political party doesn't want to back, it usually do not back a normal candidate, it only backs the star candidate. And if some person comes up saying that I have money and I can back myself, I do not need the backing of the party, okay, only a little bit of support but not financial backing, then that person is given the ticket, okay, because he has the potential to win, because the winning is all about the kind of money you have in your pocket. Now this is becoming reality in India, which is very sad, and that is the reason the importance of money has increased in the politics, and too many people with the criminal background are entering the politics, because the people with nice and clean background usually do not have money, and even if they have money, they don't want to come to politics. This is the sorry, sad affair in this country, but it's okay. We are being very positive about the future. There is another case of 2013, Chief Election Commission versus Jan Chaukidari, allowed under trial prisoners to contest election. Now, if somebody is under trial, does not mean they are convicted, does not mean that they cannot be proved innocent later on in the trial. So that is the reason why the judgment allowed the under trials to contest election. And similarly, in ADR case in 2002, mandated criminal record disclosure of candidate. That simply means you not only have to disclose your incomes, you don't only have to disclose the income of your spouse and children and dependents and you know, your property and everything, but also your criminal background. That simply means you have to tell the Election Commission that I was convicted, I went to jail, I am under trial. Everything needs to be told to Election Commission. You cannot hide, or you can face disqualification. So it's a very important article to understand. This was the article in the news recently about the petition which was filed in the Supreme Court against a lifetime ban for politicians if they are convicted. But the central government is against this view, saying that a lifetime ban is not a good idea. The finite punishment is the process which we are following and must be followed. A person who has completed his punishment must not be punished after he has completed his punishment. This simply means that his past must not be dragged in his present. This issue relates with delimitation. Now, a delimitation exercise happens after every census in India. That is very important to understand, and it is about to come. Okay, and there are concerns raised by the southern states. So this is one of the news of the Indian Express, which talks about the Chief Minister of the southern states, especially the Tamil Nadu, saying that it has been weaponized against the state that fulfilled its duties. And when they are talking about duties, they are talking about population control. Population control. Okay, so in our country, we have a parliamentary form of government. In that parliamentary form of government, we know that candidates are chosen. They fight election, they contest election, and they come to the parliament, to the legislative assemblies. So there are constituencies everywhere in India. People in that constituency choose their leader, choose one candidate from so many candidates. One candidate either could be from a particular political party or can be an independent candidate, and that particular candidate who wins the election by the system of first past the post system goes to the parliament or goes to the state legislative assembly and sits there, makes law. So in all these things, what really happens is the size and the amount of population which one constituency has, the other constituency must also have the same amount of population. Okay, I hope you got it. Now, we are going to see it a bit deeply. Let us understand the context. Context is the chief ministers, as I've already told you, M.K. Stalin has raised concerns over the delimitation exercise which is coming up. So the word delimitation, what does it mean? If you see particularly this word delimitation, what does it mean? It's the process of redrawing the boundaries. So as I told you, 2 constituencies, the number of people inside it who will be voting has to be same. Okay, we'll look at the map and you will understand it better. So redrawing of the boundaries of the electoral constituencies based on population changes. So population is increasing. Each seat in Lok Sabha, there is one person who is sitting in that particular seat, and he is representing the number of people from where he has won the election. This is one constituency. This is one constituency. But because of the population increase, the number of people inside this constituency is increasing. Let's say it's increasing with the rate of 5%, but in this constituency it is increasing with the rate of 10%, and in some other constituency it is increasing with the rate of 15%. Whereas in southern state, as they are raising the question, the population increase is only 1%. Now think about it. All these delimitation happens on the basis of population change. Here it is written, no, elected constituency based upon the population changes. So if population is changing and parliamentary form of government is all about numbers, the more number you have, then you can make the government, isn't it? The representation of the southern state who have been doing their duty of population control from many years, the representation of those have decreased in the parliament. It will decrease with the coming of the Delimitation Commission and the kind of formula it will use to delimit the boundaries. So that is the major concern of the southern states. It is conducted to ensure equal representation, but will there be equal representation? That is something to see. The constituencies of UP, where the population is increasing and has increased tremendously, are going to increase, whereas the constituencies in Tamil Nadu and the number of seats allocated to Tamil Nadu, Andhra Pradesh, Kerala are going to decrease because of less population in those states, and also because they have been, they are in doing their duty of population control from so many decades. So that is the concern. So this is India. This is how the constituencies look. The constituencies of Lok Sabha, if you look, this is a bigger constituency. This is a bigger constituency. Whereas if you see, this is the part of Uttar Pradesh. So many constituencies, smaller one are there. Now why the size of this one is bigger and the size of, let's say, this one or this one or this one is smaller? It is based on the population. For example, here 10 lakh people are living. In a smaller constituency also, in most practicable manner, 10 lakh people would be living. So it is based on population, you have to understand. And the southern states, the population is not as much as compared to the northern state, and the rate of population increase has decreased in the southern state because of implementation of the policy of population control. So they have been doing their duty, but electorally speaking from the point of view of allocation of the number of seats in the Lok Sabha, their representation in the Lok Sabha is going to decrease. If the delimitation, applies the same formula it has been applying in the last many decades. So that is the big issue here. I hope you got it. So the basic formula used is population per seat is equal to the total population of the state. If state legislative assembly delimitation is going to happen, then the population of the state upon the total number of seats allocated to that state. That simply means population per seat most practicable manner has to be same. For example, in Uttar Pradesh as of now, there are 404 state legislative assembly seats. Mostly all of them will have population in the same proportion. That simply means the population of one constituency will be almost similar to the population of another constituency, and that is how it goes on for 404 seats. So same applies for the national level and same applies for the states. So the delimitation is based on population. Very important thing. Well, making the constituencies and the whole exercise, several things are kept in mind. What are these? Geographical compactness. How much compact an area is geographically. This is how they draw the boundaries of the constituency. Similarly, physical features are seen. Mountains are there, rivers are there, what are there? So in a way, they are not going to divide a constituency in such a way that a river is going and they are going to divide it like this. Most probably, it will be along this river, so that the electoral process which takes place, takes place in an easy way without much exercise of the electoral officers to cross the river from one end to the other, and it will be problematic, isn't it? There are many physical features which are kept in mind, such as rivers, such as other mountains, and so many other things. Administrative boundaries are there, that is kept in mind. Communication facilities and public convenience, everything has to be seen, because at the basis of this delimitation, there is election, and in election people go out to vote. And if you do not keep in mind the convenience of the public, they are not going to come out and vote. Then what is the meaning of having a democracy? Now, if you see the historical background, till now there have been 4 delimitation commissions in India. First one in 1952, then in 1962, 72 and 2002. The recent one was 2002. Subsequent commission revised the constituency boundaries based on census data. Now in 1976 something happened. By 42nd Constitutional Amendment Act, 1971 census was frozen as the basis for delimitation exercises. Why was it done? To incentivize people for population control, so that they control the population, and that was the basis, that became the basis for freezing this particular census of 1971 for the delimitation exercise. Now we know census happens after every 10 years, 1921, then 1931, then 41, 51, and similarly 2011 census is there with us. Now in 2022 something happened. The freeze was extended till 2026, and now we are in 2025 and there's 1 year left. That simply means next delimitation commission is going to come up. It may take some other census, not necessarily 1971 census. Most practical way of taking up census will be 2011 census, which is the recent census. Okay. The next delimitation exercise is scheduled based on the most recent census data, which will be 2011 census, and that is why this whole politics is happening everywhere in the country. The concerns of the southern state has been raised by many politicians at the national level and at the regional level as well. Constitutional provisions related with it. Now this is important for your upcoming examination. This is important for your prelims examination and also to mention in the mains examination. If you see, article number 82 provides the reallocation and readjustment of the Lok Sabha seats. Reallocation of seats and readjustment of the boundaries. So if let's say one constituency was this big, okay, and another one this big, with the coming of the census and increasing of the population, their sizes may decrease. Because earlier, let's say there were 10 lakh people living in this constituency and almost 10 lakh people living in this constituency. Let's say this was the year 1971 or 2002. Now in 2025, their sizes may decrease because the less area contains more population because of the increase in the population size. So this smaller size may contain 10 here and 10 here. So the number of constituencies are going to increase. Okay, and this number of constituencies are going to increase in states where the population has increased. And in this manner, the southern states are coming out as losers because they did their duty of population control, and now they have to pay in 2026 Delimitation Commission. Center has said nothing as of now on this exercise. Let's see what happens then. Article 170 governs reallocation of seats in the state legislative assembly, and this one in the Article 82 in the Lok Sabha. Then there are two more articles, 327 and 328, saying different things. It empowers the parliament and the state legislature to make laws regarding elections and delimitation. So making law on delimitation rests with parliament. As far as other matters of election go in the state legislative assembly under Article 328, state legislative assembly is also empowered to make laws. Not on delimitation, but yes, on, let's say, electoral rolls and efficiency in the election process and other things. So these are important constitutional provisions in front of us. Now, what is this Delimitation Commission? How is it constituted? So it's, in simple words, constituted by the President of India. It's a very important exercise, a very important body constituted by the head of the state himself, headed by the retired Supreme Court judge as the chairperson, includes Chief Election Commissioner, respective states' election commissioners. So it is an inclusive body which is including too many people from all walks of life, and wherever there is stakes which are high, for example, MPs and MLAs from affected states are also the part of this. Although they do not have the voting rights, but they are the part of this commission to, keep their voice in front of the commission so that they are not at loss. Okay. It is finalization of the boundaries happens here. The commission drafts proposal and conduct public consultations. Its recommendations are binding. Now this is important. The recommendations are binding and cannot be challenged in court. So it limits court power to interfere in the delimitation process. The allocation of seats which has to be done will be done by wider consensus. It will include officers of the government of India. It will include chairman of the Election Commission, which is the constitutional body, the chairmen of the State Election Commission, which is a constitutional body, member of parliament and MLAs from the affected regions. The head of this is the retired Chief Justice, and it is constituted by the President. It is a very inclusive body taking care of the problems and issues which are raised by all sections of people, and interference of court is not allowed in this particular exercise. And whatever the result be of this particular exercise of delimitation, it is always binding. You must understand this. Now, what is the concern of the southern state? This is what we are talking about, the states such as Kerala, Karnataka, Andhra Pradesh, Tamil Nadu. What they are saying? They have successfully controlled the population growth over the period of time. So in one or the other way, the nation used to look towards the southern state when it comes to population control. And now for that particular reason, the whole region of southern India is suffering because the allocation of seats which are done in the Lok Sabha are done on the basis of population, and there they have decreased the population, whereas the northern states have increased the population. So the southern state are fearing, what are they fearing? Declining of representation in the national politics. Okay. Political shift towards the northern states. And of course, they have been penalized for controlling the population. So what they are saying is the whole control of politics will shift towards the northern state. Their representation in the national politics or in the Lok Sabha, in the Raj Sabha is going to decrease. That is the major threat to the southern state, major concern for the southern state. So political and legal implications, government stand. The union government has not yet announced any change to the 2026 delimitation process, and opposition view is simple. They are simply standing with the southern states. They understand and accept the reality that the southern state has been penalized for population change, and many regional parties and opposition groups have supported Tamil Nadu's demand. Because Tamil Nadu has also brought up its own formula for the upcoming delimitation exercise. Potential constitutional amendment which can be done as the demand gains momentum. The Indian Parliament may consider amending constitution to extend the freeze. Now, as we know, in 2022, the delimitation, the process of delimitation was freezed till 2026. So one of the idea is that the freeze may be extended, let's say for coming 10 years or 20 years. So it will be freezed till 2046. But this is one idea. Not necessarily the center may accept it or implement it or alter the representation rules. That as of now, population and the changes in population is the basic criteria of delimitation. There can be changes in rule which can help the southern state to get more satisfaction in the national politics. So there are possible solutions which we have written. Increasing total Lok Sabha seat, that simply means it should be proportionally increased throughout India, not necessarily decreasing the number of seats in the southern states. This is one solution. Fair representation formula, which says a new system ensuring the states are not penalized for population control, and the national consultation, which simply means discussion among all states to reach a consensus on delimitation. So it is raising questions on federalism also. Federalism also, which is also the basic structure of the Constitution of India. Why? Because the constituting power of the states proportionally will be changed because of their representation in the national politics, and hence the voice of the southern state may decrease. Earlier also they had issues with the implementation of GST, because GST has become a different kind of tax regime. They are taxing the end product rather than the manufacturing of that product. Most of the manufacturing came from southern state. So tax were collected by the southern state. Now it is a consumption. GST is a consumption based tax system. That simply means wherever the product may have been manufactured, the tax will be collected where the product is consumed. So let's say a car was made in some factory in Tamil Nadu and it was sold to a factory or an outlet in Uttar Pradesh. The tax will be collected in Uttar Pradesh. So there is no more excise duty as it was earlier, where the tax was collected where the manufacturing took place, but the tax is collected at the end point where the consumption happened. And for that reason, the southern state have lost a great share of taxation income, the indirect tax income, because of the consumption based tax, because of the GST. So that was one concern of the southern state, and now this is the another concern of penalization of population. So we have already seen this slide. So there is where our presentation ends. It is a very important exercise for the national politics, for the constitution to work properly, for the elections to happen properly, for the representation of the people and the equal and fair representation of the people. That is important. Now think about a situation where one member of parliament is representing lakhs of people, whereas other member of parliament is only representing a handful of people. Now that will not be proper. There is no equitable representation like this. So it is very important to have a delimitation process, a delimitation commission to look after the allocation of seats in the Lok Sabha, allocation of seats in the state legislative assembly, to look after the changes of the boundaries of the constituencies everywhere in India. But at the same time, no state, especially the southern state, must be penalized for population change. Panchayati Raj and why it is in distress. So the 73rd and 74th amendment was brought to the constitution in order to create a decentralized power, a sort of, to improve the federalism structure in the country and to create a third level of governance in the country, which was very important for the upliftment of people in country like India, where so many of the people live in villages. Still, maximum population lives in villages. Now there shall be some kind of governance structure in those villages or at the local level in order to develop those areas. Okay, with that mentality, with that aspiration in the heart, 73rd and 74th amendment acts were brought. But now if we see, there is an index which has came up which talks about the devolution of power. The index is the Panchayat Devolution Index of 2024, which has talked about distress in Panchayat. So distress is there because of several reasons. Now first we shall understand on what basis this index is saying that there is distress. So it has several parameters, or some of the parameters is this governance framework, the functions of the panchayats, the finances of the panchayats, the functionaries which are there in the panchayats, the capacity building and the accountability. So one important factor why there is distress is because of the accountability. There is very less accountability and transparency in the local level governance. Important thing to understand is that the governance framework is such that there are political hurdles, there are also bureaucratic hurdles in the development works at the panchayat level. Also, the state government has not devolved most of the important items to the panchayats so that panchayats can be empowered to collect taxes. So the finances are also not working properly. The functions are also not proper because they do not have the jurisdiction because of lack of devolution of items on which the panchayat can take decisions upon. Many of the states have not done that, and for that reasons even the functions of panchayats are not proper. They do not have proper mechanism, they do not have proper capacity to work, they do not have the jurisdiction to work as a local government body. So because of all these things, the report says that the Panchayati Raj system is in distress. This report is prepared by Ministry of Panchayati Raj, which is based on IIPA study, and evaluates the panchayat on 6 parameters which we have seen. So we had this idea in mind about the effective decentralization, which is now in distress. It's a very important news for your upcoming examination to understand. 73rd and 74th Amendment Act is in news, so questions can be asked. So a little bit about the 73rd Amendment Act, about the Panchayati Raj system in India, was introduced by 73rd Amendment Act. The decentralized governance for rural development. Since we have already seen that maximum population of India is living in villages, they are all engaged in agricultural activity, mostly are engaged in agricultural activity, and the empowerment of such citizens will finally empower India. So the local level governance is of great use. It is a very important topic for your upcoming examination. So there are 3 tier system. Even inside the village, if you see the village level, block level and district level, and there are regular election. The elections are held after the gap of 5 years. They are conducted under the supervision of State Election Commission, and there are reservation for women and SC/ST. 33% reservation is provided to women, which includes 33% reservation also to the women of the SC and ST community, and the reservation to SC and ST community is given according to their proportion in the population. Okay. There is also a State Finance Commission, which is a constitutional body which recommends about the finances, how much finances needs to be devolved to the state in order to build their capacity to work on their jurisdiction. But that all is not happening. That is the reason why Panchayati Raj system is in distress, this particular index tells about. So a little bit about achievement. See, everything is not at level 0. There have been development made, people have been empowered. Development has reached the ground levels because of the Panchayati Raj system. And we should be very thankful to that kind of system. But still it is not perfect and efficient. Still there is a scope for improvement. And whatever its level was, it is now decreasing. There are many reasons we have already discussed. One of the other reason is over dependence on centralized scheme, on centrally sponsored scheme. Also, that is the reason why the state and the Panchayati Raj are not getting prominence when it comes to governance because of the centrally sponsored scheme. Too many villagers are dependent on centrally sponsored scheme. So who is going to pay attention to the schemes run by the state government for panchayats, or the schemes run by, the programs run by panchayat themselves? That is the issue, apart from the finance issues and the devolution issues and the transparency and accountability and capacity building issues. So there are also achievements. For example, women participation or women development, emancipation has been great. There are more than 14 lakh women who were elected at different posts as ward member or as Gram Pradhan under this act, empowering women to a great extent. Local governance involvement, social sector programs are there, okay, and they are implemented at the Gram Panchayat level. So these social sector programs help the society to evolve, help the society to grow. They also have an economic component in it, okay. And if you educate people at the Gram Sabha level, for example, financial inclusion, opening up of the bank accounts, which were very much necessary, Jan Dhan, Aadhaar Yojana, all that linkages which has came, GEM, Trinity, that was very important. It was a social change. At the same time, it was also triggering an economic change, an economic inclusion. Okay, so both the things, the social development and the economic development, are going hand in hand with schemes. And since maximum population of India are living in villages, it is very important to run all those schemes at the panchayat level, at the Gram Panchayat level, increasing local decision making. So all these things are important achievements when it comes to the Panchayati Raj institution, but there are also challenges such as technological shifts. Now, because of the coming of AI and other important technology, people in the villages are not that much literate or do not have the kind of capacity to train themselves in these new technologies. For example, let's take an example of this UPI system, which is prevalent in urban areas, but if you go to the villages, that's not so much prevalent. Still, people are afraid of transferring money online. They are afraid that they may lose their money. So this technological shift is a challenge. How to tell the people of the villages that it is perfectly safe to pay online instead of using cash. Governance issues are there. There is a decline in participation at the village level. This is another distress point in Panchayati Raj system, and there is over reliance on central scheme. We were discussing this centralized scheme. Limited administration, Only 20% of the state have devolved all 29 subjects under the 11th schedule. So when devolution will not be there, how can we think about the local politicians having enough power to develop their area or enough jurisdiction to work in their area? It becomes very difficult, and hence the report is talking about distress. So this state-wise performance is there. The top performance are, if you see, the southern state. This is an important trend which can be asked in your prelims examination. See, top performers are Karnataka, Kerala and Tamil Nadu. Biggest improvement has been seen in Uttar Pradesh and Bihar. These are states with huge population. Population is great, and the number of villages, because the population is great and the constituencies are divided on the basis of population, so the number of panchayats will be large, they'll be great in number. So the maximum number of panchayats can be seen in areas which are highly and densely populated, and biggest improvement has also been seen in Uttar Pradesh and Bihar. Lowest performers are, if you see, these two are the northeastern state and Jharkhand. So these are important trends for your examination. Even a statement, objective or MCQ question can be framed on these trends about the performance of Panchayati Raj institutions in India, that the lowest performing states are the northeastern state. That can be made a statement in a prelims examination. Another statement can be about that southern state are the highest performing states, or showing the greatest improvement in the area of local governance. So these kind of questions can be made by UPSC when it comes to the trends, state-wise trends for performance at the local level governance. Rural population per panchayat. National average is 4,669. Okay. Most densely populated panchayat, West Bengal, Assam and Bihar. So see, Bihar is here and Bihar is here also. Most densely populated, and at the same time biggest improvement has also been seen. I hope you are understanding this video till now. Representation in Panchayati Raj institutions. If you see women representation, we have already seen about 14 lakh women have benefited from Panchayati Raj institution. They have represented one or the other levels in Panchayati Raj institution in the years after 1993, when the 73rd and 74th amendment was introduced. So their representation increased from 45.9% in year 2013-2014 to 44.44% in 2024. That's a great leap. But if you see, 44% of population engaged in Panchayati Raj institutions, it's a great thing. But from 45 to 46, this is only 1% improvement. Now these are important trends, that what has happened in last 10 years or in a decade, the improvement is very less. But if you see the overall improvement, it's good. Top 3 states are Odisha, Himachal and Tamil Nadu. Representation of the SC, ST and OBC community, if you see, highest is in Punjab. When it comes to scheduled tribes, the highest is in Chhattisgarh, and OBC the highest is in Bihar, as per the population composition of these states. So 94 crore Indians live in rural areas and 45% are engaged in agriculture. This is very important for you to understand how to develop these people. 94 crore people, that cannot be done until and unless you have a strong local bodies which are strong enough. They have their finances, they are transparent, they are accountable to the people, At the same time, devolution of funds and devolution of power has been made to them. All the 11th schedule items which are there, 29 items are listed, they must be devolved to the local panchayats in order for them to work properly and to uplift 94 crore people, to develop them. Engagement in agriculture, local level policies can be made by the Panchayati Raj institutions for the benefit of agriculture, for the economic benefit of people of that region. Those are important things. Empowered, Piara, there's a formula given here. Empowered Panchayati Raj institution means better governance, transparency and development, which is unfortunately lacking, as we have seen in previous slides. There is no better governance, there is no better transparency and accountability, and development is also lacking because of lack of jurisdiction, lack of power, and at the same time lack of finances and capacity. So PDI highlights progress, but structured reforms are needed. There are still structural reforms needed. It has been 3 decades since this particular amendment was made and Panchayati Raj institutions were introduced in India, but still there are structural reforms which are needed, and they need to be worked upon quickly because a huge amount of population are still residing. India is not an urbanized country, it is a rural country. Okay. Strengthening local governance means stronger democracy. So when it comes to democracy, democracy does not only mean what is practiced in cities or metropolitan cities, but also what is practiced in grassroots level. For that reason, it is of paramount value for all of us to pay more focus on the grassroots level, local level governance. There shall not be any kind of distress, and these kind of reports which are very important and reflects the ground level truth must be encouraged. Constitutional morality. Now you must have heard about morality while reading ethics as a subject. What does morality simply means? Morality is the power of discrimination between right and wrong. If you are able to discriminate between right and wrong, if you are able to see whether something is right or something is wrong, then you have that faculty, then you have morality. People who have faded morality are usually unable to see the right and the wrong in situations, especially in difficult situations. So the basis of that morality can be many. It can come out from the values which you have learned from your parents, from your religion, from the society, also from constitution, because constitution also holds several values such as fraternity, such as human dignity, such as equality. All those things can be termed as constitutional morality. So ability to take decision, ability to discriminate between the right and wrong on the basis of values such as equality, human dignity, liberty, all these will be termed as constitutional morality. I hope you have understood this. So this was a news of The Hindu, which it says that the origins and the nuisance of the concept. So it has covered, an article was there and it has covered the concept since the beginning. Constitutional morality is a civic culture of respect for constitutional forms and offices. So any kind of constitutional offices which are created, can be constitutional bodies or statutory bodies or any other bodies which are working for the governance and efficient governance of this country, have their values based on these principles, these important principles of equality, of dignity, of liberty, of fraternity. Okay, none of these offices which are created can go beyond these values. Who is the protector of these values? If you see, the custodian of the constitution is the court. So Supreme Court, High Court and all the courts,
They are the custodian of the constitution, and at the same time they are the custodian of the fundamental rights. They are also the custodian of constitutional morality. It is also expected from them to follow constitutional morality when interpreting the constitution. Constitutional morality must also be followed by the parliament while making the law. Okay, so I hope you are getting a grip over the concept. Now think about a situation. We all know we all understand the concept of equality. Okay, sorry, give me a second. I need eraser. Yeah. So we all understand the concept of equality. There shall be equal protection of law and equality before law. Now, in order to implement equality, if the court interprets the statute in a very strict manner, what will happen? Think of the situation. If a man has committed a crime, a heinous crime, and he has been subjected to the trial, and finally the court has awarded this man a death penalty. Should he be given death penalty? Yes, of course, he should be given death penalty. What if the same crime was committed by a woman? Now, third, what if the same crime was committed by a woman, and later on, after the trial, after the punishment was given, after the punishment was awarded, the courts came to know that this woman was pregnant? If the court dismisses the punishment of this woman on humanitarian grounds, because it is not one life involved, now there are two lives involved. Several people may come up and say this is the infringement of the principle of equality. But is it? That's the question. That is where the constitutional morality comes in. I hope you have understood this. It is everywhere. Think about another form of equality. Everybody is equal in front of law. Good enough. Everybody should be treated equally by law. The state should not discriminate any person, any citizen on the basis of religion, race, caste, sex, place of birth. That's also good. But then why reservations are given? Then why special provisions are made? Because the brute and strict interpretation of the term equality may go against constitutional morality. Some section of people which were marginalized, which were historically and educationally backward, needs more support of the country, more support of the constitution, more support of the parliament and the courts, so that they can come into the mainstream of the society, they can become the part and a healthy part, and equality can be maintained in the country. Or else there will be perpetual inequality in the society. The divides which were already there are going to increase even further. They are going to become even more deeper. And that is the reason why the focus of the court, the focus of the parliament is more on constitutional morality while making a law or while interpreting a particular statute or a provision of the law. So, if any code is made, code simply means any law is made, there is a soul of this particular law. That soul depends on humanity. Because law also takes care of the human emotion and the human feeling. Because laws are made for humans or to regulate humans. And for that reason, it becomes paramount to understand the importance of constitutional morality. That simply means the source of this law, of course, the procedure has to be followed. That must go to the parliament and parliament is going to bring the law. But the soul of this particular law, the basis of this law must depend on the constitutional provisions, on the constitutional morality, and on the principles such as equality, dignity, liberty, fraternity. If these things are missing, the law may persist, but the soul is going to die, and hence it will be of no use. Let's say if Parliament passes such a law which does not have the soul, or the elements of dignity and liberty and fraternity are missing, then it is infringing the basic structure of the constitution. So it is the duty of the court to jump in and to interpret the constitution in such a way that it upholds the constitutional morality. It should look that particular law from the prison of constitutional morality, not from the prison of popular morality, that's different, but from the prison of constitutional morality, that is it upholding the constitutional values or not. I hope this much lecture is enough for you to understand the concept. Let's see the other slide. What is the context? Recently, the Constitutional Court has adopted constitutional morality as a tool to interpret laws. We have discussed this. A test to adjudicate the validity of statutes. So whether a particular statute, whether a particular law which is passed by the parliament is valid or not, as we have already discussed, if it is missing the important principles such as it does not respect the human dignity, or it is going against the fraternity, immediately it should be struck down by the court to uphold the constitutional morality. Sometimes the court may also be questioned for doing this thing, but that depends on the moral fabric of the court, which is very strong. We believe that courts are going to implement constitutional morality in every interpretation it does, in every order and every judgment it makes against the government or in favor of the government. Constitutional morality entails adherence to constitutional values. Constitutional values we have already seen, such as dignity, human dignity, liberty, equality, fraternity, all these things. We are going to see what it upholds. Now see this, these are some of the examples of constitutional morality, and they are inserted in our constitution under different headings. If you see preamble, justice, liberty, equality, fraternity. If you see fundamental rights protects against arbitrary state action. State is very powerful. In order to stop or limit the power of the state so that it does not infringes upon the rights of the individuals or right of the citizens or right of a section of people in the society, the principle of constitutionalism has to be followed. That simply means limited government. And what limits the government? What gives the power to people over government is this concept of fundamental rights, where if it is curtailed or infringed under Article 32 and under Article 226, the citizen of India have the right to approach the Supreme Court and High Court. Okay. Directive principles, if you see this, guides policy with Gandhian social and liberal ideas. This, is a mine of constitutional values and ideals. If you see the values, Gandhian values, social values, liberal values, this is a mine, I would say. It's an ocean of constitutional values, of constitutional morality. And that is the reason why Parliament is expected to look towards the directive principles of state policy while making laws. Fundamental duties. It encourages civic responsibility. That all of us do have fundamental rights, but at the same time, we also have to follow our duties. So, civic responsibility. Responsibility of the citizen towards the nation, towards the country is upholded by fundamental duties. Very few constitutions around the world have this feature, and Indian constitution is one among them. Checks and balances. All the organs of the government, nobody is supreme, nobody is sovereign. People are sovereign in this country, and that is the reason why we do have checks and balances. We follow a parliamentary form of government where there is a constant check of parliament on the executive, and the laws made by the parliament or the actions which are taken by the executive are checked by the Supreme Court or by the high courts. So judiciary is constantly upholding the constitutional morality, the constitutional values, if the parliament and if the executive tries to go over them or tries to, infringe them or curtail them. So this check and balance is a very important provision as far as the Constitution of India goes. So origin of this concept of constitutional morality comes from Greek historian, where they have stressed upon the need to have a constitution to limit the power of the state. A written constitution helps a lot. Even if it is unwritten, there is a set of rules, a body of rules which helps to limit the power of the state. And they said, thousands of years back, that some kind of constitution is very important which upholds the morality in the society. There are several values which will be written in these constitutions, and the constitution is going to uphold those values. The organs which are made through the constitution, whether it be executive, whether it be judiciary, or whether it be parliament or legislature, they are going to uphold the constitutional morality which is written in the constitution. There will be limited government. Constitutionalism will be followed. Dr. Bhimrao Ambedkar has also warned that a constitution can be perverted without changing its form, and he emphasized self-restraint to preserve democracy. Now, self-restraint, what is this? By the leaders, by the judges. The judges should espouse for constitutional morality, not popular morality. That is where the importance of self-restraint comes. Okay. Similarly, the leaders of the country who hold immense amount of power, the executive, the prime minister, the council of ministers, they must also look towards the directive principles while they are implementing some law or while they are making a policy in the parliament. Importance of constitutional morality. There are, many importance. See, non-transactional constitution. A constitution must remain impartial. So in order to have impartiality, constitutional morality is very much important. And there are other things also. It balances the forms and operation and emphasizes on constitutional processes. So in a nutshell, you have understood the idea of constitutional morality, which is very good. And if not followed, the laws will be there, but the soul of those laws will be missing. I hope you are getting this idea. It's a bit complex idea, but it's very important for you to understand that every law, policy or legislation or provision of the law which is made must be backed by the constitutional morality. Every interpretation done by the court should be done with the prism of constitutional morality, not through popular morality, not through anything else, not through politics. So, key Supreme Court judgments, if you see, everywhere Supreme Court has been, emphasizing upon this important issue of constitutional morality. Constitutional morality is essential for good governance. Okay. There was a patch of land few years back in Delhi, and this belonged to railways. But there were few people who were living. This has become a slum area, and it was the winter season, somewhere in December or January. The administration came, dragged all these people out at night. At night. There were old people, there were children, there were women who were living here. Do you really think the step taken by government upholded the constitutional morality? I do not think so. This was a very immoral, unethical practice which was done by the government. At the end, the government was hugely criticized. The action of the executive was hugely criticized. They said that we were just following the orders of our officials. It's okay. you can follow the order, but you could do it in the morning. You can do it when the winter has passed. Think about old people, think about women and children who has become homeless just because a governance body is following its order. So, constitutional morality is of paramount importance when it comes to governance. That you are doing this, but there shall be some kind of compassion, there shall be some kind of, human dignity which you should uphold while taking any decision, while making any policy. Even if it is an order which you have to follow, you should think about the consequences, not only whether the law has been followed or not, but has it been followed in the true spirit, looking it from the prism of constitutional morality. Again, I am repeating this. Similarly, in another case, Supreme Court directed high-ranking official to adhere to constitutional morality. This case, it is fit for it. Another case, the Supreme Court linked morality to second basic structure. See, this is a very important issue. Second basic structure doctrine, restricting arbitrary power of the government. In Navtesh Singh case, it has upholded the LGBTQ rights by striking down this section 377. It has impacted the article relating to equality, human dignity and liberty and freedom. And right to privacy. Who can forget about right to privacy case? This was very important to uphold the constitutional morality in India. So courts are doing its job. Similarly, Parliament is also doing its job. Concerns regarding constitutional morality. Sometimes what happens is there is no clear definition which is given. What is constitutional morality? There is no clear definition. So maybe in some cases there is a kind of as given violation of the separation of power. One organ of the government, such as judiciary, may overreach the executive, or if it moves forward, can also make law, overreaching the jurisdiction of the parliament or legislature on the name of constitutional morality. Now, it should not be allowed. Every organ must remain in its limit. The principle of separation of power, which is the basic structure doctrine, a part of it, must not be violated on the name of constitutional morality. This is also important, and this is an important thing to keep in mind. So, constitutional morality is vital for upholding democratic values. We have no doubt in this. This is very true statement. However, courts must balance their role to prevent judicial overreach. Courts must not show any kind of overreach on executive or on legislature. Maintaining separation of power is essential for democracy. Truly. So, we have understood the meaning of constitutional morality. We have understood why it is important. We have seen several cases where court has upholded this principle of constitutional morality. We have also seen examples that if constitutional morality is not followed, the laws may remain, but the soul, the basis of that law, the ground on which that law is there, the spirit with which that law has to be implemented will just evaporate. It will be of no meaning. So I hope you have understood this important concept and can be asked in your upcoming examination. So thank you students for joining me in this marathon. I hope you have learned a lot. I hope I was able to tell you all the important topics from Polity Current Affairs. Thank you very much for joining. Jai Hind.